At the outset, I would like to compliment Team DTRTI Chennai. DTRTI Chennai, under the leadership of Shri Krishnan, our ADG, has been thinking out of box and coming out with different solutions for training and skill updation of all the officers. Recently, we witnessed the launch of the newsletter, which has been widely appreciated. Now, this is yet another initiative of technical videos, and I'm deeply grateful to Team DTRTI for considering me to do the inaugural edition of the video.
Good afternoon, sir. This is Mayuri, DCIT International Taxation, and my first question to you is: what are the significant developments in the arena of international taxation?
Now, the question you've asked me is that what are the changes in the international taxation arena? Well, to answer you uh, shortly, it is fast and furious. I mean, both in the international arena, where the focus continues to be on the OECD BEPS program, and more specifically on the signing of what is called the multilateral instrument or the MLIs. We also are witnessing that the nations and jurisdictions are grappling with how to tax digital economy in terms of BEPS Action 1, and also what are the seminal impact of tax cuts in America, how to efficiently exchange information, and how to curb the menace of tax avoidance and tax evasion through abuse of treaties or through use of what is popularly known as the tax havens. In India, in last couple of years, we have seen radical and sweeping changes in our legislation. Some very seminal changes in the law has been made, which has a very far-reaching implication for all of us revenue officers. We've also seen that the protocols with important partners, countries such as Mauritius and Singapore, have been renegotiated, and some very important significant changes have been made. Most importantly, I find that in CBDT's action plan for this year, we see a qualitative shift in the way we are to administer and enforce international tax in India.
What are the changes in domestic legislation to enforce and implement international taxation?
With regard to changes in our domestic law, I would like to mention some of the very important ones. The first one I can recall, of course, is GAR, which has been highly talked about in all the forums. India has finally introduced general anti-avoidance rules, which gives primacy to substance over form. We have also seen the introduction of equalization levy, a unique tax through the Finance Act in 2016. And in the present year, through the Finance Act 2018, India has taken leadership role through introduction of the concept of significant economic presence, which arises out of BEPS Action 1, taxation of digital economy. We have also seen that CBDT has released concrete guidelines for assessing place of effective management, and through following the guidelines, we can objectively and factually assess the poem of a particular enterprise. As I mentioned earlier, the protocols and the key ones with Singapore and Mauritius have been renegotiated, and the seminal result of the changes is that India now has the right to tax capital gains arising out of alienation of shares of an Indian company by a non-resident if these shares have been acquired after 1/4/2017. Of course, if the shares have been acquired prior to this date, that is 1/4/2017, the treaty protection will continue to be there, and these investments have been effectively what is called in popular parlance grandfathered. The Singapore DTO also has modified the limitation of benefit clause or the LOB clause, which is an anti-abuse provision, and it has been modified, and stipulations have been made wherein if the LOB clause is not satisfied, then the treaty benefit can be denied.
How to go about substance over form?
Most of these changes made in our domestic law, as well as the modification of the protocols, inescapably point towards the primacy of substance over form. Significantly, the action plan released by CBDT this year, insofar as international tax is concerned, mirrors these changes. Officers are required to make fact-based interventions. Systems Directorate is going to push data after taking the necessary risk assessment of outward foreign remittances which have been captured in the 15CA form, and officers are expected to verify these remittances. Further, the action plan also mandates that each of the TDS officer has to undertake 10 surveys or spot verifications. Now, the experience of surveys in international taxation in Chennai has been very, very encouraging. In many cases of foreign enterprises and their permanent establishments, we have been able to establish a wide divergence between what is presented to us in their agreements, which is craftily drafted and beautifully structured by the Big Four, and the facts in the ground. The ground situation is completely divorced of what is presented to us by way of these agreements and submissions. So therefore, the only way we can unravel and bring to tax such inconsistencies is by way of field verifications. The action plan also talks of bringing in new areas for verification, and I can recall the equalization levy, the LO or the liaison office of foreign enterprises, and the data which is coming out of the 15CC form, which also is towards external outward foreign remittances, but more importantly, captures data which is not captured in the form 15CA. All this signifies, therefore, a radical shift in which the officers in international taxation will function this year. These changes make our job very challenging and at the same time very exciting.
Sir, what is significant economic presence and how should assessing officers deal with this concept?
The concept of significant economic presence is a very important concept to be understood. Introduced by Finance Act 2018 by introduction of Explanation 2A to Clause 1 of Section 9(1), significant economic presence radically alters the landscape of permanent establishment as we understand it. Hitherto, permanent establishment was intrinsically linked with a physical presence. Significant economic presence endeavors to tax the digital presence. Under the present law as it stands, we cannot tax a digital presence if the non-resident doesn't have a physical presence in India and transacts its businesses of goods and services and products or even property through digital mode without having any physical presence in India. The nations, as I stated earlier, have been grappling on how to tax the digital presence, and the concept of significant economic presence has been derived out of BEPS Action 1, Taxation of Digital Economy. Now, India is one of the first countries to bring significant economic presence in the statute, through which we endeavor to tax the digital transmission of goods and services. Via the newly introduced Explanation 2A, the definition of business connection was clarified to provide that a non-resident's significant economic presence in India shall constitute a business connection of the non-resident. The explanation has defined significant economic presence as any transaction in respect of goods or services or property, including provision to download data or software. A significant economic presence also means a systemic and continuous soliciting of business or engaging in interaction with a number of users as may be prescribed through the digital medium. As an abundant precaution, it has been expressly mentioned in the explanation that transactions or activities shall constitute significant economic presence whether or not agreement for such transaction was made in India and whether or not the non-resident has a physical presence in India. It has also been clarified that significant economic presence would mean only the relevant profits which have been derived out of the business connection through the transactions made in India. The Central Board of Direct Taxes, via its notification dated 13th July 2018, has sought stakeholder comments and comments from general public as to what should be the threshold with regard to significant economic presence, both in terms of the volume of transaction as well as with regard to the number of users. The notification of CBDT in this regard is awaited. It can be stated with reasonable certainty that with the countries with whom India doesn't have a tax treaty, such as the Bahamas or the Cayman Island, the rule of significant economic presence would be applicable immediately and would apply to residents of these countries with effect from 1/4/2018. However, with regard to countries having DTA with India, the restrictive PE definition in the tax treaties would override the business connection in the domestic law that includes the concept of significant economic presence. So, unless the treaties with countries having DTAs are modified by a protocol to include the concept of significant economic presence in the DTAs, on the ground, I don't think anything would change. However, it will be interesting to see as to how does the MLI affect the concept of significant economic presence.
Please explain the relevance of General Anti-Avoidance Rules or GAR in international taxation.
It will be very difficult for me to talk about such a complex and expansive subject as GAR in a couple of minutes, but I'll try my best. GAR, or the General Anti-Avoidance Rules, have been brought into the statute with effect from 1/4/2017. It can also be seen as a statutory codification of substance over form rule. The philosophy behind the implementation of GAR is that sometimes the transactions are arranged or decorated with the primary purpose of tax avoidance, but they do meet the letter of law. If specific components of an arrangement is seen separately, they do meet letter of the law. But if the arrangement as a whole is seen, it becomes clear that the main motive of the same is tax avoidance. GAR is intended to address such situations as the specific avoidance laws in the domestic legislation, or what is called the SAR, specific anti-avoidance rules, are not sufficient to bring to tax such a transaction. GAR has been introduced by incorporation of Chapter 10A into the Act, and the relevant sections are Section 96 through to Section 102. An arrangement under GAR can be declared as an impermissible avoidance arrangement, or IAA, if the main purpose of the arrangement is to obtain a tax benefit and it covers any of the following four situations, or what is called the tainted elements. 1. That it creates a right or obligation not ordinarily created when dealing at arm's length. 2. It results in misuse or abuse of provisions of the Act, either directly or indirectly. 3. it lacks commercial substance or is deemed to lack commercial substance. What is deemed to lack commercial substance has been further defined under the provisions. And 4, is entered into or carried out by means that are not bona fide in nature. So, if these are the ingredients of GAR and these are existing in an arrangement, there is an elaborate set of procedures through which such agreements can be disregarded. However, adequate safeguard has been built while implementation of GAR because it is no doubt a powerful tool in the hands of the revenue. GAR is applicable only when the supposed tax benefit is in excess of rupees 3 crores. Procedurally, the AO has to first make a reference to the commissioner or the principal commissioner regarding a potential GAR case. The commissioner or the principal commissioner, as the case may be, after prima facie satisfaction of the applicability of GAR, will issue a notice to the taxpayer. The taxpayer will then submit his defense on why it thinks that the arrangement or the transaction is a bona fide one. The commissioner, after due diligence and examination of the submissions of the taxpayer, if he still feels that the arrangement is impermissible avoidance arrangement, then he is required to make a reference to the approving panel. The approving panel then, on due consideration of the GAR notice, the submissions of the taxpayer, and the reference made by the commissioner, takes a decision on the applicability of the GAR. As we all know, GAR is still in a nascent stage in India, and the provisions are yet to be tested. But the provisions of GAR throw very interesting and challenging possibilities for all the revenue officers in terms of the interplay between GAR and the DTAs and how the conflicting interpretations with regard to impermissible avoidance arrangement can be sought.
On behalf of DTRTI, I take this opportunity to thank Anurag Sahay sir for this tech talk.
Thank you.